All right, everybody, welcome to the newest installment of our series, GBW, Our Method for Success. How did you win that case? Today, we're going to be presenting a case involving how we proved course and scope of employment on a case involving drunk driving. And Alan Van Gelder and I tried the case together. My name is Bruce Broylette. Alan Van Gelder is one of our partners. Alan and I tried the case together. Alan did a great deal of the work in putting together the basic discovery that we obtained that made all the difference in the case and working on the legal issues. The only thing I'll say about Alan is he graduated summa cum laude from college and magna cum laude from law school, and there's evidence of that all over the quality work that he does. So if we can go to the next slide, we'll start to talk about the case. So this is an incident that happened on March 17, 2013. It happened to be St. Patrick's Day. And we all know that on St. Patrick's Day, many people go to Irish bars and hang out together and have a few and talk with people, meet people, and have some fun. On this particular day, a couple of fellows that were friends by the name of Lance Sandman and Tom George, and we represented Tom George, went to Tam O'Shanter's. So if we can go to the next slide, here's a lovely picture of Tam O'Shanter's, their publicity stuff, and showing St. Patrick's Day. And so what happened was these two fellows, Lance Sandman and Tom George, end up getting quite intoxicated at Tam O'Shanter's. And I'm sure already you're wondering, well, how could that have anything to do with course and scope on a Sunday, on St. Patrick's Day, and so forth? So let's go to the next slide, though. In doing some discovery, we were able to obtain various emails, and the other side had them as well, because Lance Sandman worked for this employer that we were suing. And at the Christmas before this thing happens, this horrible accident that happens on St. Patrick's Day, there are a series of emails between Tom George and Lance Sandman talking about going drinking. So you see the first one there. That's a couple of days before Christmas. Got time for a pint at Tam O'Shanter? Sorry, but we'll have to take a rain check. Next. This one is from November of 2012, starting at the bottom, perhaps a holiday beverage tomorrow evening. And then if you look at the one up above it, would love to hook up tomorrow. Perhaps we find a new watering hole that I have in mind. Watering hole. Language like that all through these emails. Next. Starting at the bottom, I'm making the rounds. I'm at the Tam O'Shanter and will be making my rounds. This is December of 2012, before this incident happened. The response from Tom George is, next round, the Griffin. And then Lance Sandman says, and if drinks don't kill me, her memory will. I can't take this much longer the way that I feel. So clearly bantering back and forth between these two friends at various times about getting together and drinking. And there is the Griffin, which is another bar and lounge where people could go to drink, and that's what we were talking about. Okay,
within
next.
Walking distance of the Tam O'Shanter, no less. So you could go from one to the other.
Yeah. So next. Okay, so we know it's St. Patrick's Day on Sunday. Lance Sandman and Tom George are drinking at Tam O'Shanter's. They drink a lot. They talk with some girls. And about 5 or 5:30 in the evening, they leave Tam O'Shanter's and they get into Lance Sandman's car. They were both pretty 3 sheets to the wind. Next. And you can just get a sense of the environment that they were in at Tam O'Shanter's. Okay, next. So Sandman is drunk and speeding and causes a horrific crash. Next. What happened was Tom George lived at the Prado Community Association. You see that to the right. And Mr. Sandman was the property manager there. He worked for the property management company. You see to the left, there's Tam O'Shanter. And so what they did is they left Tam O'Shanter, both of them intoxicated, and they headed up to the 134 and then driving along, and there was a huge crash at the 134 as they approached the product. Next. There you see the severity of the collision. Next. And so then the next thing that happens is the police come out and Sandman is arrested for DUI. And so the police report, and this is all the information we were getting in our first visit with Tom George and trying to decide whether to take the case. We go to the next page. We see some things from the police report. Let's do them one at a time. Okay, they were at Tam O'Shanter for a few hours having some beers and talking with some girls. Notice it says a few hours having beers, and it says they were talking with some girls, nothing about doing anything related to business or employment. Okay, then it says George, that's our client, estimated that they were going in excess of 100 miles per hour. Next. He said to the police, my friend was driving too damn fast. Next. He says, I was afraid. Next. He says he told Lance, slow the F down. Next. George said, and that's our client, he had ridden in the car with Lance before and that Lance drove the car fast because, quote, it was that kind of a car, close quote. Well, it was a muscle car. It was a very fast car. It was, as you'll hear later, even, driven on a racetrack now and then. So if we go to next, it even had a license plate that said blew by because this fellow liked to drive and drive really fast, Lance Sandman. But not only that, Lance Sandman was bombed out of his mind. In fact, Lance ended up going to jail over this whole thing. We go to the next slide. That's Lance. He was driving the car when Tom George was injured, and he claimed that he only had 2 beers. Next. The reality is that the defense toxicologist explained, and we had a hard time disputing very much, that he was at 2.5 times the legal limit. Next. That put him at 13 glasses of beer. And as if that wasn't bad enough, we also had to deal with Tom George and his alcohol intake, and he had had about 8 glasses of beer. He was above the legal limit at a 0.12 or a 0.13, but clearly we had a lot to deal with on that. So you might say to yourself, well, what a great case. How much insurance did he have? He had $30,000 of insurance, Lance Sandman. That was popped pretty quickly. So what made us take the case? So as we're listening to him talk, and we hear all these things about how this is a Sunday, Tam O'Shanter, St. Patrick's Day, the alcohol level for both of them, the speeds involved, all of that, we're thinking, what do we do here? So we asked some more, and he gave us a little hint when he said that essentially he was on the board of the Prado where he lived. That's a condominium project. He was on the board, Tom George was, and Sandman was the on-site property manager for the company FirstService, also known or changed its name to Merit. So, and what he said was, the reason we went to Tam O'Shanter was to get ideas for next year's St. Patrick's Day party. We heard that and we went, well, that seems to have a business purpose to it. So we decided to take the case, and Alan went to work. Alan?
So the big question is going to be, hi, first of all, everybody, but the big question we had is, okay, if there's a business component to this, does that mean that Sandman's employer is responsible for this? And so I'm sure we've all heard the phrase before, scope of employment, but basically the idea is If you can find that the Sandman was in the scope of employment with his employer, FirstService Residential, then FirstService Residential could be vicariously liable, fully liable for all of the actions that were taken by Sandman that day. So the question we had to decide is, okay, what was scope of employment? So if we can go to the next slide. And this is straight from our closing argument where we translated the jury instruction for the jury, by the way, so you can see that. But the first thing we had decided to find out is what exactly did Lance Sandman do for FirstService Residential? So if we can go to the next slide. So by the way, this is a picture of the Prado, and the first and this is in Pasadena, and the Tam O'Shanter is in Glendale. And the first problem that defense counsel was happy to point out to us multiple times was, aside from the fact that it's Glendale versus Pasadena, is he's a property manager. He has no business being in a bar in Glendale. They also pointed out that he worked Monday through Friday, and this, as Bruce had already said, was a crash that took place on a Sunday. How could this be scope of employment? So we had to dig further and find out more information. Can we go to the next slide? So just to give you an idea, as Bruce mentioned before, FirstService Residential, also originally known as Merit, they're a property management company, and they did the property management work for the Prado. The Prado was a condominium. It was run by a homeowners association. And every year they would get a fee, and every year the homeowners association would decide whether or not to renew the property management contract with FirstService Residential. So in a way, Lance Sandman had his supervisors at FirstService Residential, but his customer, the people that he had to keep most happy, were the folks at the Prado. And the homeowners association had a board, and that board was organized to run the Prado, and it was Chris Krasick as the president, Tom George, our client, as the vice president, secretary treasurer Reagan Elliott, and member at large at Otto Peterson. So these were his most important customers. So as we started hearing more about it, and as we were talking to Tom was like, well, look, he was there whining and dining us all the time, mixing business with pleasure with us. He was taking us out, doing all these things. And when you start to look at how it's organized, you go, okay, this is Lance Sandman trying to keep the people who renew the contract happy. So the discovery, we focused on not only Sandman's interactions with Tom George, but his interactions with all the other board members. If he's treating all the board members the same way he treats George, then we've got a shot to say, hey, this could be scope of employment. Anyways, the next slide. But then we get this from defense counsel. Now, this was written in October of 2012. So keep in mind, this is like 6 months before the crash. And we're saying, hey, it's course and scope that Lance Sandman crashed the car with Tom George in it. And then they show us this email. This is Lance Sandman writing to somebody at FirstService Residential HR, Jackie Schwartz, saying, I am not planning to drive in the course of my duties at this time. So we saw that, and defense counsel kept showing it over and over again. They love this email. And this is something else we had to deal with on top of everything else. Now, remember this email, because defense counsel starts out loving this email at the beginning of the case. But by the time we're done, and by the time we do our right homework, doesn't look like it now, but this email is going to be a very big problem for the defense. So just keep that in mind as we go along. If we can go to the next slide. So as Bruce said earlier, one of the things that Tom George said was, well, we were out scouting for the St. Patrick's Day party that we were going to throw at the Prado. And the calendar, the Friday before the crash, there was in fact a St. Patrick's Day party that Lance Sandman had organized for the folks at the Prado. So again, that did fit into the, we were there for a business purpose. But the thing is, when developing the evidence, you got to not only develop the evidence to get to the past the trial judge, you got to get it to something that convinces the jury, and you also got to deal with the Court of Appeal. And so the argument we were going to get was, well, you were planning the March 2014 St. Patrick's Day party 1 year in advance. But our point was, well, if you were looking at Tam O'Shanter for ideas for St. Patrick's Day, you got to go on St. Patrick's Day. But this was another issue that sort of was getting batted around during the case. We can go to the next slide. So how did we develop the evidence for scope of employment? So before we talk about that for a little bit, I think it's important that we sort of talk about how do you go about proving scope of employment. I'm sure we've all heard cases before where people are driving home from work, or people are on a lunch break, or they're picking up their dry cleaning, and there's legions of cases out there where is this scope of employment or is it not? And so a case that I felt was really helpful with it for this case, and I think for scope of employment cases in general, why don't we put up the next slide? If there's one case I can steer you to for scope of employment, it's this case right here. It's Purton versus Marriott, and there's the citation for it right there. It lays out very nicely all the scope of employment cases all in one place. It has a nice set of facts to go with it too. It involved a bartender who was catering a party at the Marriott, and he was getting drunk with some of his customers, and he crashed the car. Horrific facts. The court goes through all of it. And they talk about, but the concept here, and this is what helped guide us in discovery, and was every time the facts of the case got really rough for us, I would go back to. The court in Purton pointed out that for scope of employment, if the risk is created within the scope of employment, it follows the employee and the employer as long as wherever they go. And the court had a really good analogy in that case. They talked about a hypothetical situation where what happens if somebody's working in a nuclear power plant and because of negligence, they become radioactive. They then go drive to a basketball game with their friends and they infect the friends at the game with the radioactive material. Again, playing basketball isn't obviously part of a nuclear engineer's employment, but he became radioactive while employed. And so until his radioactivity goes away, he's still a danger and the employer is still responsible. So if you've got, so our feeling was here, if we could show that, look, Sandman became radioactive or drunk during his course and scope of employment, all right, driving fast, driving stupid, all of these things naturally flow from being drunk. If he becomes radioactive while drunk, here you go. Anyways, so one of the things we did to do is we went and we got the employment file, because you can get all sorts of great stuff in the employment file. The interviews, the job applications, the background check, the performance reviews, pages of emails going back and forth between Sandman and HR, and also with some of the members of the board. This is where we found all of the good stuff. And as we started going through it, we started saying, no, St. Patrick's Day is not an isolated incident, and definitely in scope of employment. And I'll pass it over to Bruce about some of the stuff we found in the employment file.
Well, and before we leave this slide, let me make a couple of points. Number one, it takes a lot of effort to pursue and chase down all of these kinds of documents, and there were tons of them that we ended up getting produced. They, as you will see now, form the essence of the case that proved course and scope. But also, you know, it so often happens that things just get produced and then aren't studied, aren't followed up on, motions to compel aren't done. You've got to stay on top of it. You've got to stay on top of the defendant, and you've got to push to get this kind of information. So let's start looking at what we found as we started to get some of this stuff coming in. So the next slide, we titled this Hidden Gems in the Employment File. As we all know, the juries love to see what's in the documents. Okay, so let's go to the next one. All right, so before we highlight what I want to highlight here, this is a letter, if you look in the upper left-hand corner, from May 9, 2013. And that is a letter that was written in the process of dealing with the aftermath of Lance Sandman. Are they going to have him work? What kind of work are they going to do? All that stuff before he ends up in jail, okay? In that letter, they make a statement that completely impeaches the thing that said, you know, that email Alan pointed out earlier about, I understand that I do not drive in the course and scope of employment, that sort of stuff. So look at what we found in this letter from Merit, which is FirstService. It says, as you know, and this is to Lance Sandman, as you know, your current position requires that you drive in connection with your job duties. Well, so therefore, whatever they were saying in that email Merit FirstService was recognizing in this gem in this document that his current position requires him to drive in connection with his job duties. But there was also another little thing after the comma. It says, and work closely with the board at Prado. Now that was a precursor of what we're going to find as we proceed. So point number one, we could now establish that yes, driving was part of his job. So let's go to the next one. Was mixing business with pleasure within the scope of employment? So remember, we just because driving's in the course and scope, just because driving is part of his job doesn't mean that all of a sudden we launch to, and therefore socializing on St. Patrick's Day and getting drunk and then going out and driving 100 miles an hour and getting in an accident is all within the scope of employment. We needed more than that. And so with Alan's persistence, we got the stuff that we needed for trial. So next. It turned out that Lance Sandman was being encouraged to do a lot more than just be a 9-to-5 property manager representative at the Prado. These are some of the communications from employment to him before this incident happened, talking about what they want him to do, what his employer wants him to do, and praising him for the things that he had been doing. So let's start with this one. This is in 2010. Encourage more social events for residents. Well, let's just stop there for a second. Isn't that what was going on that day? Weren't they working on ideas for next year's St. Patrick's Day party? Next. Praising him for the St. Patrick's Day get-together that he'd already had. Obviously, that's encouraging him to have good St. Patrick's Day party events in the future. Next. I think this is a large part of why you, Lance, are getting so many rave reviews lately and the residents of the board feel so well taken care of. In other words, this is more than just bringing in the plumber when there's a stopped up toilet. This is developing a relationship with the members of the board so that they feel so well taken care of. And who was the vice president of the board? Tom George. Next. This is from the FirstService materials, and look at how they describe their relationship with their customers. We care for the people and communities we serve, that would be the Prado, as if they were family, because to us, that's exactly what they are. Next. You know what? I've got to plug in my computer here for a second, just one moment.
While Bruce does that, what I would tell you is that this is another performance review, and as you see from this performance review, Lance Salmon is saying, I go out of pocket for Saturday morning coffee and croissants, I work late, stay weekends. That sort of ended the defense argument that, look, this was a guy who was 9 to 5, Monday through Friday. Here they know he's doing work even when it's on the weekend. So if we can go to the next slide, Bruce can take over again.
And what happened was I had unplugged my computer and it was starting to show, so I plugged it in. Okay. He often gets glowing remarks or emails from board members and residents. They really love you. Next. This includes service above and beyond by way of the excellent social and community building events you create and produce. Just remarkable efforts here. You are ahead of the curve. I mean, he is being told and motivated to get very involved with these board members, and there's a reason why, as you'll see. Next. Your humor, your can-do attitude, solution-oriented, out-of-the-box purveyor of fine events has made it so wonderful to work with you. Manager comments. Next. Encourage more social events for residents. These are all things we found from before St. Patrick's Day in 2013. Next. Continue to build strong working relationships with board of directors, which includes Tom. You often go above and beyond, which means weekends, evenings, paying things out of his own pocket, all the stuff that's designed to develop a very close relationship with the board members. Next. And then this was sort of the one that I really loved. This is Lance Sandman back to Greg Lotane at FirstService Merit. And he says, I will try to make Merit as indispensable and intertwined to Prado as I possibly can. Wow. Anyway, next. And here's the reason why. Because of your good work, Lance, we are able to take an increase in management fees in 2012. Why? Who decides on agreeing to a higher contract? The board. Who was on the board? Tom George. Work the board, and there's a financial motivation and a financial benefit to the company if he does the sorts of interpersonal relationship stuff just like he was doing at Tam O'Shanter's on St. Patrick's Day, March of 2013.
Bruce was talking about the thousands and thousands of pages. I had to go through thousands and thousands of emails between Lance and the board, and Lance and other people in HR. And we're talking about everything, about how the potted plants look, if the lighting is right, is Mrs. Stevenson in condo 15 curbing her dog properly. And as your eyes start to glaze over, you're like, why am I doing this? And then you start to find the emails, and the emails start showing that here's Lance Sandman mixing business with pleasure, working the board, not just Tom, but all of the board members, and doing things out of the off campus, including things involving food, drink, and everything else. So we can go to the next slide. Here's an example, one of these great social events that Lance Sandman was planning, taking everybody from the Prado to a tour on the Getty. So now we've got Lance taking people to a place outside of the Prado. And this was in 2011, if we can go to the next slide. As part of that, now this was one that we really liked, Lance's plan was after they took everybody to the Getty, everybody was then gonna go afterwards to an Irish bar and pub to have alcohol after the Getty event. So now here we are, Lance Sandman is taking members of the Prado to a bar and having alcohol with them. So now St. Patrick's Day of 2013 doesn't seem so far-fetched. This was happening almost 2 years before the crash. Next slide. And also here we are, here he is chatting up Reagan Elliott and Chris Krasnick about restaurants. And so once I had this email about restaurants and barbecue, I was asking Reagan and Chris during their depositions, hey, did Lance Sandman take you out to restaurants? And what did we find out? Absolutely, he totally did. Sometimes we did it for social reasons. Sometimes we did it for scouting out things. And here they are talking about restaurants and about maybe catering for the Prado, because the defense's whole theme was this was just two friends having drinks on St. Patrick's Day. So the more that we could show that it wasn't just Tom, it was the whole board, and Sandman was working all of them, the easier it was to defeat that pretty powerful defense narrative from the beginning of the case. We could go to the next slide. And so I'm not going to give you every single email, but we found a bunch. Trips to restaurants, trips to bars. At one point, Lance took various board members on driving tours in the Blue Bay there, all over Los Angeles for famous Hollywood landmarks. He took Tom George and Otto Peterson to a Dodger game. They went to Oscar parties. He picked up their dry cleaning, took some of them to the airport. At one point, Lance Sandman actually took Otto Peterson to a racetrack at Willow Springs. Otto Peterson had a fast car, and so did Lance, and they were racing 100 miles an hour as part of a racetrack event. It was a controlled private track. But here he is on a weekend racing with another board member. Now suddenly speeding doesn't seem so unforeseeable and crazy. This happened the summer before the crash. There's the Blue Bay racing on the track. So when we've got all of this stuff now set up and we have all of this discovery, then when we start deposing Lance and we start deposing the board members, they sort of have to be backed into a corner because the emails are there, the evidence are there, and what are they going to do? Deny it? And look, the board members were not exactly helpful for us because A, they liked Lance and FirstService Residential. I think they were worried the Prado would get claimed anyways. So Chris and Reagan sort of had to be, shown the evidence before they had to finally concede. Same thing with Lance. So now we're going to show you a couple video clips briefly. Two of them are going to be of Lance Sandman that were taken right before he went to jail. He reports to jail on February 20th, and then one of Reagan Elliott, and then we'll come back in a minute. We're encouraged to sort of mix business with pleasure, correct?
Yes. And as part of your friendship that you developed with Mr. George, would the two of you see each other on a social basis?
On occasion, but it always had a work component attached to it.
What do you mean when you say it always had a work component attached to it?
There was discussion about the building.
What types of discussions?
The aesthetics, the personnel, policies and procedures.
Me, I mean, he was a manager. He was interesting. I'd like to stop by and talk to him. Yes, it was nice of him to take my husband and me out. I don't think he would have if he were not the manager and my husband wasn't, an influencer of other people who lived there.
So anyways, there was one other clip where after Lance Sandman was required to look through all of his performance reviews, I asked him, hey, so Lance, isn't it true that you mix business with pleasure? And Lance basically is looking at all his performance reviews and he's like, yeah, I was encouraged to mix business with pleasure. And that's how you get a wonderful soundbite that then you can show to the jury, especially since Sandman's not going to be at trial. He's in prison at the time. I think he got 8 years for causing that crash. And that Reagan Elliott quote, look, he's friends with us, he's taking us out because we're influencers, that played in perfectly to what we were talking about. And again, the defense wanted to say two friends having drinks. No, this is Sandman influencing members of the board and capturing the influencers for the benefit of the company. And with that, I'll pass it back to Bruce.
So what do we have so far then? We have that drinking is part of the job. We have that socializing is part of the job. We have that weekends are part of the job. What about all this alcohol being part of the job? Whether it is within the scope of employment is really the right way to say it. So let's look at the law on that subject. And these are from the closing argument and summaries of jury instructions and so on. If anybody needs any help on the jury instructions, give us a call and we'll give you guidance as to where we found what we found, because it was very helpful. And let me also remind everybody that you can download this PowerPoint when this is over, and so you can go through the stuff yourself. So conduct is within the scope of employment if A, it is reasonably related to the kinds of tasks that Lance Sandman was employed to perform. Okay, and then or, and we underline or because it's in the disjunctive. It's one or the other or both. So was this reasonably related to the kinds of tasks Sandman was employed to perform? It seems to be. Get close to these people, become their buddies, become like family, and our contract is going to go up by keeping these people on the board happy. Or it is reasonably foreseeable in light of the employer's business or Lance Sandman's job responsibilities. Once again, all the evidence that was developed from all these emails and messages and so on fit into that perfectly. Next. So one of the things we had was the policy manual for the company as of the time this incident happened. A couple of very interesting things in there. One of them was all employees are viewed as representatives of the company, whether at work or participating in these events. Now look at that, whether at work or participating in these events. So even if you are not at work, which probably means the 9 to 5 part of whatever, I mean, it's unclear. If you're participating in one of these social events, you are viewed as a representative of the company. And then they had a drinking policy, which was very interesting. If we can go to the next one, it's a line or so down. The company expects that such consumption, now that's the consumption of alcohol, will be in moderation so as not to reflect negatively on the company's professional reputation. Well, look at all the stuff that proved for us. Number one, they could foresee and expected people to be taking alcohol while in the course and scope. Consumption will be in moderation. Number two, they didn't define moderation. What does that mean? You're limited to nursing one drink, or you can have 5 drinks, or over a period of time. What in the world does in moderation mean? That's left up to the employee. And third, it is a lack of recognition that some people, we know a certain segment of society, cannot control their alcohol intake once they get started. And that also, even for those that can, that once you start drinking, you become less inhibited. And you start to maybe have another one and another one until you're carried away. What were they doing, saying that consumption while on the job basically will be in moderation? Of course, all of this was foreseeable, and of course, all of this was within the course and scope, including alcohol, and including, as you'll see, ending up carrying that radioactivity along with him out onto the 134 freeway, threatening himself and Tom and other people as well, driving at nearly 100 miles an hour. Next. So, scope of employment. Another one from the jury instructions, an employee's unauthorized conduct. So even though Lance Sandman didn't send an email or make a phone call over to Merit FirstService asking for permission to go to Tam O'Shanter's that day, even though it says an employee's unauthorized conduct may be within the scope of employment if the conduct was committed in the course of a series of acts authorized by the employer, or the conduct arose from a risk inherent in or created by the enterprise. The jury instruction fit perfectly. Whether they authorized this or not, they are responsible for it because they knew it would happen, and it was part of the job, the way they were trying to get him to do it in developing these relationships with the members of the board. And with Reagan Elliott, her husband's a member of the board, and Chris Krasick and all these people that were on the board, those are the ones he was taking around and whining and dining. Next. An employee's wrongful or criminal conduct. So 100 miles an hour on the 134, right? An employee's wrongful or criminal conduct may be within the scope of employment, even if it breaks a company rule or does not benefit the employer. So first of all, it didn't necessarily break a company rule because he was allowed to drink, and the definition of moderate was unclear, and they wanted him to be doing this anyway. And on top of that, it did benefit the employer because the goal was to raise the value of the contract with the product. Next. Even another instruction, even social or recreational activities are within the scope of employment if they are carried on with the employer's stated or implied permission. Well, it was stated pretty clearly in all those gems that we already saw. And they provide a benefit to the employer or have become customary. Well, they clearly had become customary, and they provided a benefit to the employer because the employer, FirstService Merit, was able to raise their rates. Next. So you all know the definition of negligence. This was all through my closing argument, as you can imagine, and explaining to the jury that we have the law of negligence. It's very simple, and it's for the benefit of everybody, that we have the law of negligence. You held accountable for the failure to act as a reasonable person. And with course and scope, well, anyway, we're going to move on to the next thing where Alan's going to explain some little issue there that he dealt with very adroitly.
So when we pled the case, we pled it with the typical standard complaint, which was the person was acting within the course and scope of employment, the company is vicariously liable. But we also put in there that the company was independently negligent for negligent supervision and retention. Basically, we're saying that even if Lance Sandman was not acting in scope of employment, they were still negligent for leaving him on the job. They should have fired him or well ahead of the job. So At this point, I'm going to talk about negligent supervision and retention for a moment, because as the case was going along, scope of employment was getting all the attention. But as the discovery was coming in, we started developing information that started to really support a negligent supervision and retention case. And when people ask us, how did we end up winning this case? I think ultimately the turning point during the trial came with respect to the negligent supervision and retention claim. And here's why. We've deliberately withheld this fact from all of you guys, because right now during the trial, you know, look, the defense had this, they were drunk on a Sunday, St. Patrick's Day. How could that be work? We had our fight on scope of employment. Everybody's, you know, punching each other, and, you know, it's a battle. But then there was one explosive fact. Jury did not hear about at the beginning of the case, and they didn't hear about it until the middle of the trial. And that's this. Lance Sandman, prior to March of 2013, had 2 prior DUI convictions on his record. One when he was about 23 years old, but the other one 5 to 6 months after he became employed with FirstService Residential. And I want to walk through that for a moment, because this was a big judgment call the defense had to make during the case, and it was a big turning point in the case. But let's walk through the drunk driving conviction here for a moment. Lance Sandman was hired in March of 2007. He was arrested for drunk driving in August of 07, 5 months on the job at FirstService. He was convicted in September, and his California license was suspended from September of 07 to March of 08. Now, keep in mind, California driver's license. I'm emphasizing that for a reason. Lance Sandman had lived in Florida at one point, and in his background check, when he was providing it to the company and everything else, he gave them his Florida driver's license because he didn't want him to learn that he had been popped for this driver's DUI when he was 23. And so he took the hit on his California driver's license, but he kept on file with FirstService his Florida driver's license. FSR, FirstService, doesn't learn that Lance Sandman had been convicted in 2007 while an employee of FirstService until after Tom George's injury, 6 years later. So we can go to the next slide. So the defense has to make a judgment call here. The reason why FirstService Residential learned about Lance Sandman's driving DUI from 07 is because after the crash, they enrolled Lance Sandman in what's called the employer pull program, where basically the company, you authorize the company to have a computer program that pings you every time something happens at the DMV. If you get a speeding ticket or a drunk driving conviction, DMV sends an email to your employer, and your employer goes, what's going on? So they made Sandman enroll in that after the crash, and that's when they finally learned, hey, he had this 07 conviction. Our point was, well, if they had done this before the crash, they would have learned about the DUI, and maybe this wouldn't have happened. The defense had to make a call on it, and they decided, look, we're going to move to exclude this in limine. So they excluded it, both DUIs, saying it was remote in time, prejudicial. They've got some code sections here about the DUI from when he was 23 is too old because they're not allowed to ask about convictions of a certain age. And mainly they said, look, if FirstService doesn't know, how can this be relevant? And our judge, we had a judge who was from a hub case, so we were assigned a trial judge. He parachuted into the case roughly at the same time as the jury. Judge said, look, based on what I'm hearing right now, I'm going to exclude it. But look, I'm going to exclude it without prejudice. If you can develop evidence along the way, we can revisit it. So defense counsel makes the gamble. Look, we want to keep out this DUI, but they run the risk that it might come in. It's this bomb sitting there in the courtroom waiting to detonate at any time. So let's keep going. Next slide. So anyways, we keep telling the judge, hey, look, it's relevant several times. And as the judge is watching the evidence comes in, he's starting to get it. Finally, we make an offer of proof to the court. And you can do an offer of proof in writing or you can do it orally. But I cannot stress this enough. If you're having a piece of evidence that might be excluded at trial and the judge is excluding it, an offer of proof is basically laying the cards out on the table. Your Honor, if we put the evidence in front of the jury, this is what's going to happen. Here's what the witnesses are going to say, and here's how it's going to be relevant to the case. You do that to convince the judge, number one, but number two, if you ultimately have to take it up on appeal, the Court of Appeal needs to understand what would have happened had the evidence actually been introduced. So the offer of proof not only helps educate the judge, but it helps bolster or protect you on appeal. So here's part of our written offer of proof here that we made, where we laid out all the elements that went into what we're going to talk about now, this 2007 prior DUI. Next slide, please. So our point was this, because the judge was like, look, it happened 6 years before the crash. How is it relevant? And we said, look, Your Honor, Lance Sandman covered this up 9 different times during the life of his employment at FSR, including 6 months before the crash. And so this thing was very relevant, close in time to the question. It's not just the prior DUI, it's Lance Sandman's cover-up. His repeated efforts to lie to his employer demonstrate that he's unfit to be in this job. And if FSR determines he's unfit to be in this job, they have to fire him because he's in this position of trust, whining and dining all of these people. And we were able to show through all the discovery that there were at least 7 different times that if FSR had actually paid attention to what was going on, they could have caught that he was lying, caught the DUI, and fired him before the crash. So I'm going to walk through that for a minute now. If we go to the next slide. By the way, here is our expert that we use for both course and scope and also negligent hiring. This is Jean Seawright. She's out of Florida. She was awesome. And the point is, we said, Your Honor, we have to have a separate hearing on this offer of proof. She's coming in from Florida. We've got a couple FSR PMKs. You've now seen some of the evidence. Let us all lay it out for you because we got to have all of this covered before these witnesses come on. So we have this hour-long hearing outside the presence of the jury. Anyway, let's go to the next slide. So one of the people that was at HR who knew there was a problem was Angel Van Dyke. And by the way, she no longer worked for the company. Very sweet lady, very nice, very charismatic, very pregnant. I had to cross-examine her on over Zoom, or the equivalent of back then when we did it. And one of the things we decided to do was not to record her on video because we felt she was going to look awesome on video, and it would be better if we just read her transcript into the record cold. Anyways, as you'll see here, there were a number of instances where Angel Van Dyke goes, hey, what is Lance doing? I'm getting a Florida driver's license for a guy working in California from 2007 to 11. Didn't look at the background check. She's not asking Sandman until 2011 about to get a California license. She says, why do you still have this license? Because I live in Florida. Didn't verify a residence. Let's go to the next slide. And here you go. As you can see, this is basically, we're going to go through a little faster, but basically these were the email exchanges where she's like, why do you keep giving me a Florida license? And he explains, I still have a residence, which was a lie. And then finally, she says, hey, I want you to go get a California driver's license within the next 30 days and give it to HR. This was nearly 2 years before the crash. And but he doesn't do it, and Angel doesn't follow up. And then, by the way, if you actually look at the background check in question with the Florida driver's license, Angel Van Dyke should have realized that by the summer of 2012, that Florida driver's license had expired. Hey, Lance, I can't use the same driver's license that you've been giving me all these years. What about a California license? What's going on? She missed that. Let's go to the next one. So here's the big thing. And actually, let's move this back for a second. If you can go backward for 1 second. So I talked earlier about this employee pull program where we register all the people who might drive in the program so the DMV might ping you. And so they're trying to get everybody into this program. And Jackie Schwartz, the head of one of the HR heads, is explaining why it's important. She's sending this email to Lance's supervisor. Hey, I need to know everybody who's driving because we have to get them into the pull program. And why is that? Now, if we could blow up the big part of it. Right here, please note, if the employee is not enrolled in the program, but at some point drives and involved in a crash, this creates liability for the company in the event of property damage or harm. So we're showing this all to the judge as part of the offer of proof. And now let's go to the next email. And so this is Lance Sandman's boss saying, these are the people who need to be in the program. There are only 2 people who don't need to be in the program, and it ain't Lance Sandman. He's saying Lance has to be in the program. So this is in July of 2012. Next slide. Now remember this email at the beginning. I am not planning to drive in the course of my duties at this time. This was the email the defense loved so much at the beginning of the case. This is what Lance is writing to Jackie Schwartz. I don't need to be in the DMV pull program because I'm not driving. if Jackie is looking at the emails correctly and is talking to Angel and looking at all the facts and talking to the supervisor, they know this is a lie and that Lance is lying. And the reason why Lance is lying, because he doesn't want them to find out about that prior DUI that he lied about and he could get fired for. So we're showing the judge, look, this is evidence 6 months before the crash that Lance Salmon is still trying to cover up that 2007 prior DUI. That's negligent hiring and supervision. And our expert Gene Seawright's going to come in and is going to say it. And then the light goes on for the judge, and the judge is like, yeah, I'm reversing my motion in Lemonade. You can now talk about the prior DUI. So what happens? We then go and we start questioning and laying the foundation with the Angel Van Dyke testimony, and also with the moment, the first time the jury heard the word 2007 DUI, it's like one of those nature shows where you see all those alerted the predators. It was like they all instantly, they were paying attention to the case, but like it just, everybody perks up that extra level. And because the defense, look, they made a judgment call, understand completely, but because there had been no prep for it, it came like some surprise bombshell Perry Mason moment, and it sort of became electric. And I feel like that is at least where we felt the case was starting to turn. And then Bruce then took everybody to town for it, and Bruce can explain.
So you go to the next slide.
Oh, by the way, this is the DMV slide you would get that shows you from the pull program you had the prior DUI. So next slide.
Okay, so Beverly Petty of FSR, she's the next witness, and I have her on the stand, and I'm cross-examining her, and I now can talk about the failure to get him into the pull program, which would have told them that he had been convicted of a DUI on the job some years earlier, which our experts said would have made them either terminate him or restrict his use of vehicles in his work. And so I'm cross-examining her, and we get to this point here. Next. Mr. Sandman back in 2012 should have been in the pull program, right? Yes, she missed it, meaning one of the people at the company. Somebody dropped the ball, right? And she said, yes. To the credit of the defense lawyers, they didn't try to mealy-mouth it or anything. They just were straight ahead, and we got along with them very well. And they just recognized what all this evidence was, and then she just testified, somebody dropped the ball. You can imagine that that line found its way into several portions of my closing argument. So I'm just going to drop a footnote here. I want to tell you a story about a moment in closing argument. Alan, I'm going to do it, okay?
Of course you are.
So you know, I'm in closing, and I get to the point where there's a particular issue. It might have been this one right here, where I just knew the jury was with us 1,000,000%. And I finished the point, and then I extended my arm to the right, opened up my fist, and said, mic drop. So
and then
Alan,
a small piece of my soul died right there. No, I'm kidding. But I did my best not to roll my eyes in front of the jury. But some of the jurors thought it was cute, so it's okay.
So Alan, by the way, I don't recommend doing that very much. You've got to really feel like you've got all 12 of those jurors with you in order to do something like that. You don't want to anger somebody over it. But anyway, Alan proceeds to send a text to the office sitting at counsel table saying, Bruce actually just used mic drop in a closing argument. So this comes up at lunch a few days later, because we often have lunch together, talk about ideas if we're not in trial or depot or whatever, and anybody that's at the office, we go to lunch and we share ideas, and the synergy is great. And so somebody brought that up, and so you said mic drop, and everybody was kind of teasing me about mic drop, and I looked at them all and I said, I just have one simple response. $12 million net verdict, mic drop. So I just had to tell that.
Yep, and my soul continues to die from it. No, I'm kidding. All right, let's go to the next slide for a moment. So one thing on the special verdict form, and we're running low on time, so I'm not going to get into it, but on the special verdict form, we had two separate sections for both scope of employment as well as negligent hiring and supervision, and the jury had to do percentages for both of them because vicarious liability, it's just FSR and Sandman together, but for negligent hiring and supervision, it's FSR and Sandman separately. And I can show you all that if you're interested. Let's move to the next thing, which is comparative fault. As the case develops and the liability picture starts getting clearer, then the big pitch becomes, well, hey, Tom George is drunk. This is Tom George's fault for getting into a car with a drunk guy. Even though Uber and Lyft weren't huge back in 2013, by the time the case gets to trial in 2017, everybody's Ubering and Lyfting. So, you know, they're trying to play that up. Why did George get into a car? If Sandman's at 0.2, he must be 3 sheets to the wind, as Bruce says. How come Tom George doesn't know? Because Tom himself is drunk. And they're basically trying to say, let's blame George for being drunk that night. So how do we keep down comparative? So the point we wanted to emphasize, we can get to the next point here, it isn't so much what Lance Sandman's alcohol level was, it's what kind of signs and symptoms was Lance Sandman displaying to the universe and conceivably Tom George when he was at 0.2. So if we go to the next slide. And so while it's true, 0.2 is a lot of alcohol in it, we had evidence that Lance Sandman was a very experienced drinker. He had prior DUI convictions. He could hold his liquor. He went out drinking before. And he had the ability to hide his drunkenness. And so how are we able to prove that? Well, we looked at the ER folks who arrived at the scene because Sandman was also injured in the crash, as well as the triage nurse. You would think if Lance Sandman was displaying, if he was drunk, slurring his speech, his eyes were rolling in the back of his head, all these things, it would show up in their reports. And so let me go to the next slide here. How many times in a traumatic brain injury case have you seen the defense go, well, the plaintiff had a Glasgow coma of 15, he couldn't have been badly hurt. So for once, we got to use that against the defense. Lance Sandman had a Glasgow coma of 15. We said clearly if he was slurring his speech, dizzy, falling over, he's not going to, or if he was out of his mind, he wasn't going to get a Glasgow coma of 15. Go to the next slide, please. And so we had the ER docs, the ER nurse, and we had the 2 EMT guys. They didn't remember this at all, but they had their records, and they showed these were all the things that Lance Sandman could do, even though he had a 0.2. And obviously, if he was drunk out of his mind, it's something they would have noted because you can't give Lance Sandman certain painkillers if he's drunk out of his mind. So we were like, look, if Lance Sandman could have fooled ER docs and EMTs, he probably could have also fooled Tom George, which is why ultimately on the verdict form, we were able to hold Tom George's comparative fault down to 20%. So anyways, and next slide. And we had, this is Dr. Donald Barsalou. He was our toxicology expert, and he explained that, yeah, even though you are drunk out of your mind at 0.2 and you should not be driving, he explained that different people handle 0.2 alcohol differently, and experienced drunks do have the ability to hide their symptoms. So he's very helpful for us keeping down comparative fault on Tom George. Bruce?
Yeah, so we're going to talk now about damages. So you all know the gross verdict was 15 million, and with 20% comparative fault, the net was 12 million. Before I do this, Alan, I'm not picking up. I can see that there's some questions here, but if you can get those ready so that we can deal with them after we're done with damages.
Sure.
For some reason, it's not coming up for me. So it was a very, very bad arm injury. And it was to a 49-year-old guy who was single, lived here in California and worked here in California. And if you can give me the next slide. This is Tom George. So this is the fellow that we met that day on that first interview when we decided we really like him. We see the germ of a case here, and we're going to give a shot at this and see what we can develop. Little did we know what would be developed in the case, in the discovery. Next. You can see him, you know, fortunately we had these pictures of him with his arms uplifted. Tom is a very nice person. Gentle, strong, kind, funny, the right combination, all the stuff you love to see in a client you're going to represent and that a jury would love. Tom grew up in Chicago. He got a couple of degrees in engineering, in the engineering field. He then went to work for a company and then moved over to a company named Amcor. Amcor had been his employer for years at the time that this incident happened. He was rising in the ranks by the time he was 49. As I said, he was single. He also had and has a wonderful girlfriend who was every bit the great witness you would hope that a girlfriend or friend or spouse or whatever would be to explain what had been going on in this person's life. Just so important. You know, the people we represent are just so important. And they are, regardless of whether they're nice people or not, because we decide to represent them and we got to do the best we can for them. I don't need to misstate anything there. So Tom was also quite athletic before this happened. He played golf, he rode bikes, he jogged, he played basketball. He was a pretty big guy. I could imagine he was a pretty good basketball player. And so he rose up in the ranks and he rose to the point of being manager of one of the company plants out here in Southern California, living in Pasadena at the Prado. So, and by the way, his charisma and his kindness and his warmth is probably reflected by the fact that he was elected vice president of the Homeowners Association by his fellow homeowners. So it all fit together of a piece. Next. There he is. Once again, we had all these great pictures of his arm raised up and outstretched. So next. Okay, so Alan, why don't you describe what this issue was?
So one of the things there, first of all, in order to save his arm, they had to take a piece of muscle out of his back, and they had to use that muscle to string his arm back together. There were like 30 surgeries from the crash to before the trial started. And so we had some graphic videos and presentations showing how that process was. I'm not going to show you the video now. This is just a still from it. I'll give a shout out. This was work that was done by High Impact. One little tip on this, though, is the defense objected a couple times, saying, look, it was too graphic. At one point, we had a knife come in showing the knife cut. At another point, they had to take some of his skin and put it through a cheese grater and then attach the skin that way. And the defense was like, this is too graphic, Your Honor. And plus, he was asleep during the knife cut, so he didn't feel the pain. So the judge said you could show this, just don't show the flying knives. The cheese grater is relevant. So I had to, on the fly, basically pause the video, black it out so the jury wouldn't see the flying knives, and then they could see the cheese grater and all the other things there. So just obviously, these graphic company people are great. Just remember that some judges might find it a little too graphic, and be prepared to work on the fly as needed. So go ahead, Bruce.
Okay, so let's go to the next one. Here's what it looked like. Now I'm just pausing for a moment. That was Tom George's right arm. This good-looking, athletic fellow was dragging this thing around and is all through his life. He's had 30 surgeries, many of them attempting to reduce down, if you can go to the next slide, to reduce down this giant weight he's carrying around on his right side of his body. It was as bad an arm injury as I've ever seen in all my years of practice. He could have considered amputating it, but that was just more than he could handle. The hand is essentially non-functional for him. The arm gives him pain. He has many surgeries coming up in the future to continue trying to reduce this, because Tom continued trying to work for Amcor. Tom continued because he loved his work and is just a working kind of a guy. He tried to carry on with his life the best he could. But Amcor was losing interest in Tom quickly. And he suffered a demotion. and he was taken back to Michigan, which was not good for him because the cold weather is terrible for Tom and his injury. Not only that, but the medications he had to be on, the loss of balance that he was experiencing, the falls he would have, and one of his big fears was that he would have a fall and fall on his right arm. In doing his work for Amcor, he had to go up and down, scaffolding type, not scaffolding, but the metal stairs at a plant and so on. He had to do all that sort of stuff, and it wore him out. It tired him out. So as a 51, 52, 53-year-old guy by that point, it was just wearing out, and he was petrified that he was going to be losing the job. So what about the lost earnings picture? Let's go to the next slide. So loss of earnings, here's what we had to contend with because he was a successful guy and had a really good job. Next slide. This is his employment data history. Now remember, we're talking to jurors, many of whom have never earned this much money in that time frame. So as of the year of the incident, the year before 2012, you'd see he'd risen to 179,000. In 2013, he had 3 months, I think it was, in the hospital dealing and with surgeries and rehab and so on before he could even try to go back to work. So his income really dropped down that year. And then look at 2014, $190,000. 2015, $182,000. 2016, $188,000. That was a combination of base and a percentage bonus that he would get for performance reviews and so forth. But in getting the demotion, that was starting to go down. And one of the real problems was it was going to be capped. And he was not capped before this incident happened in his future, but now it was going to be capped. Plus, he just couldn't perform quite the same. And he had, as I said, this great fear that he was on thin ice with the company. So if we could go to the next page. So we had all of these key concepts on the loss of earnings picture, the transfer to Michigan and the demotion, new job responsibilities, which required him to travel a lot. And travel for Tom is extremely difficult because of all these issues, dragging that arm around all the time. And then, of course, the cold weather in Michigan. Next. The toll on the body and mind back at work. You can imagine the psychological impact that this has and had on Tom George. And he was just sort of magnanimous and kind about it. I don't know how to describe it. Those are not the right words, but he was accepting. It was remarkable. The jury loved him, obviously, by the verdict. That this employment, even though it's a lot of money, it's just not sustainable. Next. Pain and more surgeries. Next. That he was on thin ice. Next. Shortened career trajectory in work life. Of course, he's going to have his work life start to drop because he's not going to be able to do this until he's 65 or 70. At least that's what the testimony was. Next. And the defense expert's focus was too narrow. For example, the defense expert didn't even include a discussion about the cap that was now on his income and how that was going to affect his future, even if he kept the job. In any event, what ended up happening was the jury returned their verdict, and they returned about $1 million for past medicals, HAL adjusted. They returned $75,000 in past loss of earnings, $1.5 million in future loss of earnings, which we had proven through the use of the work that Len Matheson does in Voc Rehab and some of the other experts. They returned about $2 million for future life care plan materials, including all the surgeries and so on. And then I believe it was 11.5 million for his pain and suffering. And they reduced that by 20% because of his comparative fault. And that's what this case was about. And I hope that this helps to give you all some ideas about how to develop under the law of California the notion of something being in the course and scope, even though initially you might not have thought it was. So with that, Alan?
So yeah, thank you, Bruce. I'm gonna go through a couple questions that I've seen right now, and so we're gonna talk about them for a minute. We had one question. It referred to the slide regarding the company policy, and I'll read the paragraph since it's gonna be too hard to get back to it. Basically, the company policy about the slide about how all employees are viewed as representatives of the company. The first sentence was, the company, client, or vendor-sponsored activities, which may include the service of alcohol beverages, are not included in this policy. So the question was, well, did that line cause a problem for your presentation? The answer is ultimately no, because we had Gene Seawright go through the policy and procedures and explain that there were all sorts of conflicting messages throughout the policy and procedure manual. And so later on, there was the drinking in moderation slide that sort of canceled out that sentence. But the other reason why that line was important is even though it's not officially part of the policy, it showed that drinking alcohol while on the job was foreseeable. So it was still relevant for us anyway. Bruce, another question that's come in is, what did you do about that statement that Tom George gave in the police report? Was there anything to be done about that?
Yeah, so yeah, it had to be dealt with. So one way it was dealt with was that Tom George, at the time that the police were talking with him, had his arm virtually hanging by a thread off of his body. He was heavily medicated, very confused, got some stuff wrong, and the jury forgave the fact that those comments were in there. For example, it wasn't quite 100 miles an hour, although it was getting up into that range. Yes, they did talk with some girls there. He acknowledged that, you know, they were socializing and getting ideas for next year's St. Patrick's Day party at the same time. None of that was in the police report could defeat what we found in the documents. Alan, your thoughts?
Yeah, and again, it had again, the officer got some things wrong in the statement. We had the audio and you could hear George's slurred speech, and you could also hear that the officer got some of the stuff wrong, but the officer wasn't paying attention to course and scope. He was looking for, was Lance Sandman driving drunk? So as a result, everybody was forgiving that there were some errors on that. Let's see here. Next, there was a question about, was there a conflict between Sandman and his employer? Yes, at one point there was a conflict between Sandman and his employer. He did have separate counsel at one point through his $30,000 insurance policy. And at one point, he also did file a workers' comp claim. We were never allowed, though, to bring that into evidence at all. The judge kept that out, and there wasn't much we could do about it anyways. But he briefly did that, but he eventually gave up everything. He paid the 30 grand and he disappeared. So he wasn't at trial. He had no counsel at trial because he was in jail, and the jury knew about that. Let's see here. Did Sandman testify favorably to the plaintiff about course and scope? He sort of did, and he sort of didn't. He sort of like tried to thread the needle on that one because he was upset he was going to jail, but he was also upset that his employer sort of hung him out to dry. And the problem is Lance Sandman was basically lying at various points. So nobody could really hang their hat completely on Lance Sandman because it was demonstrated he was lying to the company and lying about everything. So that's why we had to find all this other stuff in addition to just Lance Sandman's word on it here for a moment. Here, hold on one second. I'm trying to go through a couple of the other questions here for a moment. I can't see all of them. Someone had asked about costs. Yeah, this was an expensive case. We had to hire a number of experts. There was also a traumatic brain injury element to this. So we had to do the whole mild traumatic brain injury workup. There was a question of, well, they were like, look, he's at his job. How could he possibly be injured? And we had neuropsychologist Dan Zahler, Les Zackler explain that. The jury went with us on that. There was also the big thing of pain management. We had a pain management expert. Her name was Dr. Amy Magnuson out of San Diego. She was great. She explained what it needed to deal with for all the pain. The past medicals, there was a question about that $1 million in past medicals. Yeah, that was the $1 million that was paid back. I mean, obviously it was a lien. And so, that was the $1 million that went to the insurance company folks, subject to all the lien stuff, which is a whole other webinar. But anyways, the jury was just told it was $1 million in past meds. The defense stipulated to it, rightfully so, because if they weren't, then we had the surgeon who testified brilliantly anyways, the treating surgeon, his name was Kang, out of Pasadena, and he went through in graphic detail all of the things he did to save George's arm. And trust me, you weren't going to fight whether that surgery was reasonable or necessary after he was done with the testimony. Let's see, other questions here. Was Lance, first of all, question, Bruce, they asked, did we focus group this case?
I never acknowledge on a particular case whether or not we've done 1 or 2 or 3 or 4 focus groups. So I'm not going to say with regard to this case, and you know that about me, Alan. But what I will say is we do a ton of focus groups, and I'll just drop it at that.
Okay, but not mic drop it. Okay. The other question they had was, can you tell us something about the jury? What was the jury like?
Yeah, I think they were wonderful, as it turns out.
Too, but who were they?
It was there was nothing that particularly stood out. There was an interesting thing. Our jury consultant suggested that we keep a patent lawyer who was on the panel, and we did. We understood the reasons why, and based on our research and stuff, and why it should be, and that patent lawyer ended up becoming the foreperson and ended up voting in favor of this verdict. So it was the right call. So that was one part of it that stood out. Alan?
We also had we actually had an engineer on the jury as well, plus some people who had battles with alcoholism. And so there was a big question about, do we keep the people with battles with alcoholism on the jury? And do we keep this engineer on the jury? And ultimately, without taking too much time, we ultimately felt that the people who were battling with had battles with alcoholism, they got what this case was about and what it was not about, and more importantly, the importance of not messing around when it came to drinking and driving. The engineer turned out to be just fine. It's always the gamble, but we knew who was coming up on deck, and it was literally we went through all of our peremptories. And so basically we knew it was down to this engineer or this other person we had on the panel. We had to get rid of that other person. We had an okay feeling about the engineer versus the person we had to get rid of. So we had an engineer, a patent lawyer, a few folks who had alcoholism issues, and ultimately it was the right mix, and they connected with George, they connected with the case, and it worked out great.
Yeah, by the way, for the younger lawyers, for those who have not tried or not tried many cases, for law students, I just want to mention this. When you're doing jury selection, you need to make a lot of judgment calls along the way. Keep in mind that you have to consider what's coming up. You can't just say, well, I don't like that person, so I'm going to get rid of that person, when you might have somebody, that's the president of an insurance company coming up behind. Now, that's an extreme example, but the point
by the way, that was the last guy. Thank you for reminding me. He was somebody who worked for an insurance company. We had to get rid of him. So he showed up and we're like, he's gone.
You've got to consider the group that's in front of you, that what you think the dynamics of that group will be, where the leadership will be, where the energy in that group will be, and also, if you use another peremptory, who's coming up next and what's that going to look like. So it's a lot that goes into it. It isn't just, I don't like that juror. Okay.
Other questions we had is, were there any motions in limine that we filed, and how did those work out? So one of the things that we did, well, 2 of them that came up, one, There were some emails from Sandman where Sandman was boasting to a friend that he got the car up to 140 miles an hour, and the friend was like, "May your days be free of bacon while you're on the road." And we were like, "Look, nobody knew about that." And he was probably talking about Willow Springs, so the court excluded that. The other thing is the defense did want to get heavily into the dynamics of the accident. Lance Sandman almost killed a couple other drivers on the road. We brought a motion in limine saying, look, we sent an RFA to the defense saying, admit Lance Sandman was negligent. Admit Lance Sandman's negligence caused the crash. Admit that Lance Sandman was 100% at fault for the crash. The defense had to admit all of that. The moment they did that, we said, Your Honor, look, there's no dispute here that Lance Sandman caused the crash. Why are we getting into all the details of the crash, who might have been killed, who might not have been killed? We'll tell the jury he was speeding. They can get the 100-mile-an-hour thing in front of the jury, but we're not going to recreate the crash in all of its gory detail. It's going to be a waste of time and it's prejudicial, and the court agreed. So those were two motions in limine that I remember. Let me see about any other questions here for a moment. Hold on. I'm having trouble reading some of these questions on the form, so just bear with me, everybody, for 1 second.
And if there's any questions that you have that we haven't answered or that you want to talk about further, feel free to give us a call. We enjoy talking about the cases we tried and all our cases to the extent we can.
Hold on, let's see. Hold on 1 second. Someone asked, is Purton going to be helpful with respect to somebody falling asleep on the wheel? I think Purton has a point about that. Yes, if the guy is working so many hours at the job that he's fatigued when he leaves the job and falls asleep while driving home, I would definitely argue that he became radioactive or fatigued at the time he left the job, and the company should have the ability to say, hey, this guy doesn't look fit to drive. I'm not going to let him go home until he gets a rest. So yeah, I think Purton would be very helpful on somebody falling asleep at the job.
Alan, for those who might not remember or weren't on at the time that you mentioned Purton, tell them what that is and give them a case name so they can find it.
Again, it's Purton versus Marriott. That's the case where they talk about the bartender who got drunk with his customers at a holiday party, and it's in the slide presentation. Hold on 1 second. Let me see what this question is. Isn't Jean Seawright an employer expert witness? How did you get her to provide assistance? Jean Seawright, essentially, she does both plaintiff and defense, first of all. But second of all, Jean Seawright's whole point is employers have to do things the right way. And there's a right way and a wrong way. And she's like, look, if I saw this when I was hired to consult for an employer, I'd tell them, change this whole policy. You can't be doing this stuff. She definitely was, and that was helpful for her credibility. She's like, look, I defend employers just as much as I also, go out after them. And there's a right way to do things in a wrong way. And this was definitely the wrong way. And she had a lot of credibility on that front for us.
She was a powerhouse. Period.
But yeah, I agree. Obviously, it could come to be a problem. Wait, hold on 1 second. Why was there comparative negligence? What did your client do which caused his injuries? The argument essentially is, and you can look in the jury instructions, there's some cases about people who drive with passengers. Basically, a person who is drunk is given the same standard of care as someone who is sober. So the argument is that George knew that Lance had been drinking. Even though they weren't together the entire evening, George knew he was drinking and should have known at point 2 something was wrong. And basically the argument was that if George was not intoxicated, George might have been able to realize he was getting in the car with somebody who was drunk. So that's why they were able to get that even though George was not driving. Essentially, it was someone who was sober, the argument was, would not have gotten into the car. Our retort to that again was, yes, but Sandman didn't look drunk, or didn't look to the point drunk where it completely went against George. So,
and we're just about at the witching hour at the end of our time.
Yeah, so there you go.
That worked in perfectly. You can get the site on the Purton case if you download the PowerPoint that we've used here. You can find the citation there and take a look at that case. I think it might be very helpful to many of you. And appreciate you all joining us. Hope you got some benefit out of it, and we'll have another one in 2 weeks. Okay? Thank you.
Thank you very much.